Good afternoon. Okay, so we're on bad reason number 3, why people don't file for Social Security disability when they're disabled. We went through 1 and 2 out of, there's at least 9 here from this article that I drafted for somebody for a newspaper. But they're all bad reasons to not apply, so I wanted to put them out there. The first one was people that think you have to be bedridden or wheelchair bound or so severely unable to really do anything, no productivity whatsoever, or else you're not going to win disability. You're not actually disabled. Fallacy. You can check that out. That's the first one in this little series I'm doing. The other one was those that think that SSD is a handout, some sort of charity, welfare, etc. And we explain how that is not so. And you need to rethink that whole idea because it's not. It's the exact opposite. So the third one, here we are. I get this a lot when I ask people, gosh, you've been out of work for 2 years. What happened? And it seems like a lot of times the thought process is, well, I can't work right now, but I think I'm going to improve within a year or two. So I will, delay it, because then maybe I won't have to file at all. Here's why that's not really sound thinking. And I do get, though, not filing the week after you stop working because of an impairment, because in all likelihood, for most people, you're not going to know that it's going to necessarily last the durational requirement of a year. And we probably have a video on some of those requirements, such as a duration requirement. But, and keep in mind, the duration does not mean the year has to have passed. But if someone thinks they're going to only be out for a couple of years, it's not permanent, 2-3 years, I can't file. That's not true because there's something called a closed period. This means that if let's say you become disabled and and the medical records all spell it out, you could not work for, a year and a half. And you file and you prevail and you prove you couldn't work for that year and a half. And then you improved and then you could go back to work whether you did or not, but your medical records show that you improved enough to go back and do something. Even if it's a minimum wage, easy job, that would mean you're no longer disabled. So if that's the case, why not apply? Because you would get a year's worth of benefits, back benefits for that year and a half. And if you're in the middle of that year and a half, you can still file. You're still out of work, you're still disabled. Now you're starting to feel better. You have a pending claim. You don't cancel the claim. When you get to the point where you think you could go back to work, or maybe you don't think you do, but maybe an adjudicator will eventually think you can, and the medical records evidence notable improvement, you can still kind of amend the claim to a closed period. And while the first 5 months of that disabled year and a half would not be payable because of the 5-month waiting period, that nobody likes, but it's a necessary aspect you have to know about. There would be, if you were out for 18 months, you would have 13 months payable to you. I mean, if you have a $2,000 a month, primary insurance amount, that would be, a nice chunk of change. If you have $1,000 a month, that would be $13,000. So why leave that on the table? You bought that insurance, so make the claim. And yes, you can make it for a closed period, even one that's in your back window, as long as it's only very recently in your back window. And this is another reason not to delay, because they never pay you more than 12 months before the date you apply. So if you wait 3 years to apply for a pass period of a year and a half, you're not going to get paid, right? Because they're only going to pay you 12 months. The 12 months preceding, it's really like 17 months because of that first 5-month waiting period. But so you can't delay and then ask for a closed period that is, more than a year out the back window or so. So again, don't let the fact that you know you can't work right now, and yeah, it's been a year or it's going to be a year, but then I'll be back in the saddle in another year or two. You're leaving money on the table. And on a more pessimistic note, I suppose, sometimes we don't recover like we think we're going to. And then we really kick ourselves because we let 3 years of back benefits that now we can prove, they're not going to be payable because of that rule against paying retroactivity beyond 12 months before the date of application. All right. It's probably a good point right now to point out about the protective filing. You can protectively file if you're about to scroll out of that 12-month plus 5-month waiting period and you haven't filed yet, and you're still on the fence about whether you're going to. Well, I think you should, of course, if you are unable to perform, virtually all the jobs out there for the time being. You can get that protective filing date so that even though you're not going to get your full application fully in another 5 months, when you make up your mind, you will have protected it back to, say, August or September of 2023. And maybe you don't get your application until February when you're finally like, yes, I'm going to do it. All right. Okay. That's it. Bad reason not to file is when you think you're going to be getting better in a year or two. If you're in your first year and you think you're going to be better in a few months, I totally get it. Once that year is up, though, for sure, don't wait any longer. Okay. And of course, if you ever need someone to review it for you, just give me a call. Talk to you later.